In Chapter 24, we're going to discuss labor law. And labor law really comes out of the First Amendment, which gives people the right to organize. It gives employees the right to organize. And labor law is really a creation because of the tension between business owners and employees. Labor law came to be so that business owners couldn't take advantage or overly discourage participation in unions, and unions couldn't get too big and overly harm business owners. So a labor union is an organization that acts on behalf of all employees in negotiations with the employer regarding terms of their employment. It's a lawful assembly protected by the First Amendment and by federal and state statutes. The law of unions is, as it says in this slide, an economic tug of war. Is a give and take between two economic theories. So first, the Keynesian strategy that approves of governmental control, and the Austrian school that supports a laissez-faire approach to the economy. So a tension between basically a hands-off regulation. The Austrian school would say, we don't want to impose any regulations on the free market, and we will let the free market decide how to treat employees, compensate employees, the types of contracts and benefits provided to employees. And then the Keynesian strategy that allows the government to control some of these. So it mandates that the government provide a living wage or provide a certain number of days off, provide time off to have a baby, things like that. The first real regulation in this area was the Sherman Antitrust Act of 1890. It was designed to break up the great anti-competitive trust of the 19th century. And it was an Austrian-like tactic designed to encourage competition in the capitalist economy. These investigations happen today. I was just listening on the news about the latest investigation into Google. So the government, the Federal Trade Commission, who regulates these antitrust actions, have been investigating Google and its regulation of basically your search results. So if you want to search for something, Google promotes its businesses and its commerce above just the free market commerce. And the allegation in the investigation is that Google controls too much of that. It's restricting competition because Google is only showing consumers what it wants to show consumers. The Clayton Act of 1914 was a Keynesian-like tactic that forced companies to cooperate with union organizers and thus helped keep people employed. One of its goals was to hamper the federal court's ability to issue injunctions to stop union activities. It forced businesses to recognize the role of unions as a way for employees to protect their rights. And the federal judicial system, however, effectively destroyed this when the Supreme Court amended Clayton by adding two criteria that allowed the court to actually issue injunctions freely to stop labor activities. The Norris-LaGuardia Act of 1933 was passed to prohibit federal courts from issuing injunctions against union-organized strikes, and it forced companies to cooperate with union organizers and thus help keep people working. It supported union activities by forbidding the courts from using injunctions to stop picketing or boycotts organized by unions. The general goals of labor organization are to create a seniority system to protect workers' jobs from arbitrary layoffs and replacement with cheaper labor earners, upgrading worker status through wage and fringe benefit increases, and sponsoring laws that improve social, economic, and political conditions for workers. The Norris-LaGuardia Act was just one step down the road of labor law development. Later labor laws both promoted the aims of labor unions while also preventing unions from becoming too powerful. Many different types of unions have developed over the years since the advent of these acts. Whatever their form, though, labor unions have several objectives in common, which we just went through. All right, so I'm not going to read all of this to you, but this is the 21st century labor crisis. States are starting to really push back against unions. You've probably seen it on the news. My husband is a fireman, and they are always fighting about their pension system with the city. So states and cities are really starting to push back over these issues: health insurance, pension plans, merit pays, strikes, collective bargaining, fiscal emergencies. All right, and these are the acts that we just went through, a summary of these acts and a few that we didn't really touch on that are major federal labor legislation to protect both labor unions and employees. The Wagner Act, which was back on that slide, it gives workers the right to organize by allowing them to form, join, or aid labor unions. And it also establishes procedures for representative elections and collective bargaining. All right, so collective bargaining is when you allow, as a member of a union, you allow the union to bargain on your behalf. So the union will basically write your contract and will negotiate with your employer on a contract that covers all members of the union. You are not allowed to negotiate individually on your own behalf for your contract. After a union has been chosen to represent the employees of a business, that union can only bargain. Individual workers cannot. The union has the exclusive right to bargain with management, even if the employees don't agree with how the union is handling a matter. So that's one thing people don't love about unions, even if they are a member of a union, is sometimes the members of the union will vote on a stance that may be counter to what you want, and you're not allowed to defect and negotiate on your own behalf. The Wagner Act is also known for its creation of the National Labor Relations Board, which hears and rules on charges that unfair labor practices have been committed by employers or unions. So unfair labor practices might be interference with the employee's right to organize, domination or interference with the formation or administration of any union, discrimination to encourage or discourage union membership, discharge for charges filed or testimony given, or refusal to bargain collectively. Employers are not allowed to interfere with the employee's right to organize. Remember, we said this was a constitutionally protected right found in the First Amendment. So an employer cannot interfere with employees when they are forming a union, selecting their representatives, voting, striking, picketing, or engaging in any other protected and legal acts. Now, there are workers who are considered integral to the public safety that are not allowed to strike. So policemen, firemen, for example, are not allowed to strike because of their relation to the public safety as a whole. Businesses are not allowed to dominate or interfere with the formation or administration of any union. An employer cannot form a company-run union for its employees. They can't do that because we don't want to form a union, or we don't want to allow companies to form a union that will then bow to the wishes of management. It's also an unfair practice to aid one union over another, place employer spies at union meetings, reward some union officials, or agree with a union that a closed shop will be maintained. So a closed shop is defined as a work site in which the employer hires only union members in good standing. And a union shop is a place of employment in which non-union workers may be employed for a trial period of not more than 30 days, after which the non-union workers must join the union or be discharged. Constructive discharge is also a way that a business could discriminate or encourage or discourage union membership, and it is not allowed. This occurs when an employee is demoted to a job with lesser pay or authority or poorer work conditions than a previously held job, or when the employee is subject to supervisory harassment. So this is, while you're not actually fired, it forces you to quit because your working conditions become so terrible you do not want to work there anymore. A company cannot fire someone for charges filed or testimony given. So an employer can't discharge or otherwise discriminate against employees because they file charges or give testimony under the Wagner Act. The courts interpret discrimination under this provision to include discharge, layoff, failure to rehire or recall, and transfer of covered employees. A business cannot refuse to bargain collectively. Issues must be discussed willingly, free of delaying tactics, coercion, and harassment by both sides, and the employer has no duty to agree to any union demands, but they must meet with the representatives at reasonable times, and they must bargain in good faith. The Taft-Hartley Act, we're going to talk about that now. The Labor Management Relations Act of 1947 is called the Taft-Hartley Act. That's its kind of nickname, if you will. It established a means to protect employers in collective bargaining and labor organization matters. It also prohibits union officials from using coercive or abusive tactics against its own members. And a list of unfair labor activities that unions as well as employers were forbidden to practice was added to those of the Wagner Act. So it established a means to protect employers in collective bargaining and labor organization matters, and it prohibits union officials from using coercive or abusive tactics against its own members. Some things covered here under this act are state right-to-work laws, limiting the power of the National Labor Relations Board, a free speech provision, an employee anti-coercion provision, secondary boycott, national emergency strikes, and other prohibited union practices. And we're going to go through each of these in the next slide. First, the right-to-work laws. These are state laws that prohibit labor management agreements requiring union membership as a condition of getting or keeping a job. So these laws outlawed the closed shop and the union shop. So state labor relations laws have not applied to unions and businesses that are involved in interstate commerce and that are governed by federal labor laws. But it has created special rules with regard to state right-to-work laws. So this is one of those scenarios where both the state government and the federal government laws are acting on businesses. So a fully state business completely doing business in the state of Texas, for example, can't have a closed shop or a union shop. This state right-to-work law doesn't necessarily apply to businesses, though, that conduct business through interstate commerce. The next thing that the Taft-Hartley Act covers is secondary boycott. So it's an unfair labor practice for a union to strike against an employer because another employer uses non-union employees, to strike against a general contractor to force the contractor to stop dealing with a subcontractor, to ask employees of another company not to load trucks carrying the products of a company the union is striking, or to refuse to work on products made by non-union employees. So a secondary boycott is really a conspiracy in which a union places pressure on a neutral customer or supplier with whom the union has no dispute to cause the neutral entity to cease doing business with the employer with whom the union has a dispute. Some other prohibited union practices include the following. Unions can't refuse to bargain collectively with an employer and must give notice to the employer of an intention to strike prior to the termination date of a collective bargaining contract. They also can't do what's called feather bedding, which is a requirement that an employer keep unnecessary employees, pay employees for not working, or assign more employees to a given job than are needed. Next, we're going to cover the Landrum-Griffin Act, which contains a Bill of Rights provision and a hot cargo agreement. The purpose of this act was really to end or clean up the corruption and violence that had been uncovered in the internal affairs of unions. So first, the Bill of Rights provision. It's going to require all unions to adopt constitutions and bylaws and to register them with the Secretary of Labor. And it requires unions to submit annual reports, so just more transparency and disclosure. It also prohibits hot cargo contracts. So in a hot cargo contract, an employer voluntarily agrees with a union not to handle, use, or deal in non-union produced goods of another employer. So this was an amendment to the Taft-Hartley Act, making this unlawful. The National Labor Relations Board is a governmental commission that has the authority to enforce the Taft-Hartley Act and its related laws. It has the power to act when cases are brought before it, but only in cases in which the employer's operation or the labor dispute affects commerce. So this is another thing like we've talked about before. The federal government is only allowed to act in areas of interstate commerce. So for this National Labor Relations Board to have the authority to act, the employer's operation must be one that deals with interstate commerce. It has investigative, regulatory, administrative, enforcement, and judgmental powers, and it can make its own rules of procedure, conduct investigations into unfair labor practice charges, compel individuals to appear with papers relevant to the controversy, hold hearings, and issue orders. All right. The NLRB, National Labor Relations Board, can require arbitration when there are disputes, and arbitration is going to involve the submission of the dispute to selected persons and the substitution of their decision for the judgment of the NLRB. If arbitration fails, a hearing is held, and if a complaint is valid, a cease and desist order may be issued, which means basically stop what you're doing. They might restore the parties to the state that existed before the unfair practice began. So, for example, a wrongfully discharged employee could be reinstated with or without back pay. Evidence at the hearing that does not support the claimant is dismissed. The Taft-Hartley Act is going to encourage labor and management to agree freely on the settlement of disputes. There is a federal mediation and conciliation service, and it can act by itself or upon the request of either side to a labor dispute, and it offers non-binding suggestions for settling the dispute, requires the parties to negotiate, and forces a vote by employees on an employer's offer. So this is when we have disputes that we can't settle. One of our first steps is going to mediation, and there is a federal mediation and conciliation service that will basically provide solutions, provide ideas for solutions for both parties to agree, because the government, of course, wants the parties to agree to a dispute solution on their own. And then finally, the right to strike is limited. The right to strike in the public sector is limited. I touched on this before. But strikes by police, firefighters, refuse collectors, so trash collectors, air traffic controllers, postal workers, and other public employees who perform vital services are generally illegal unless specifically authorized by statute. And the U.S. Supreme Court has affirmed lower court rulings that there's no constitutional right to strike against the federal government. So strikes by federal employees are substantially more than merely unfair labor practices. They are illegal.